Hi everybody, I'm Chris Morgan. I run techgc.co.uk. I'm a commercial lawyer, so I work as a consultant on tech law, IP, contracts, related matters for a variety of startups and scale-ups. And in this video, I'm going to talk about fundraising preparation for startups and scale-ups, getting ahead of the game. What can you do to make fundraising and investment raising a bit smoother, a bit easier? What can you do up front? That's what I'm going to talk through today. So the fundraising landscape is a complex one, and startups and scale-ups will probably feel that they're fundraising most of their time, the founders, the exec teams. It feels like there is a constant process of fundraising because it takes a long time to get things over the line. There might be a first close and then tail end of investors coming in. By the time that tail end is all sorted, it's time to actually do the next funding round because more money is needed for more expansion and the next things that the business wants to do. So you'll see this progression from seed to Series A, Series B, Series C, Series D, Series E, etc., 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 until an exit. But it's perpetual. It's a perpetual process for startups and scale-ups, fundraising. And there's a myriad of different types of investor, from angels, VCs, corporate investors, family offices. Types of investment that people are seeking could vary from equity, debt, hybrid, various different things that can be done there. But as a macro trend across all of this, what we're definitely seeing is that investors are increasingly selective and due diligence processes are increasingly tough. So getting funding over the line is increasingly harder. So preparation is vital, and that is what makes a key differentiator. Getting investors on side and ready to invest definitely involves having the right people, the right team that's talking to the investors, potential investors, the right messages, so business plans, financial plans, goals and aims, and being able to talk through what your business is doing. That's absolutely fundamentally important. Also, it's really important to have the right governance assurances ready. What do I mean by that? Being able to talk through that you have the frameworks in place that will protect the investment that you're seeking. So there are corporate governance policies and procedures and frameworks in place protecting the company. There are contractual frameworks, there are compliance frameworks, all of these legal issues that will be explored during the due diligence process. Thinking about those up front, having good clear messages that can be incorporated into your investor presentations will make things smoother. And here's a great quote: "Success is where preparation and opportunity meet." So that is your incentive to invest time and energy and thought processes into the preparation at an earlier stage as possible. So this slide and the next one is a list of key things that you can do in order to prepare for due diligence processes, to do your pre-investment housekeeping so that everything is in great shape when it comes to actually getting investors over the line, getting investment into your business. So first, make sure your company's house filings are up to date. Linking with that, the second point, make sure that your compliance filings and registrations are up to date. For example, everyone in the UK that processes personal data, which is most organisations, needs to register with the ICO. Make sure you've done that. If your business is FCA regulated, if you're regulated by other regulators, depending on the sector that you operate in, then make sure that you've done your filings, your registrations, you've got your licenses, and all of that preparation is done early on. And then that you have policies and processes in place in your business to emphasize the importance of compliance and that achieves compliance with the applicable regimes that apply to you. Thirdly, make sure that you understand your constitutional documents, the articles of association, the shareholders agreements, the background, if you like, the frameworks that govern how your company is structured, and that you understand the basic shareholder rights that exist in the documentation, the provisions that apply to founders, and make sure that your contracts with directors, including non-exec directors, are in place and up to date. Everything's consistent and aligned, and you've got that corporate framework that is robust and that investors will be pleased to see when they're digging into all of this as part of the due diligence. Fourthly, on the IP side, make sure you've got a clear IP strategy, a story to tell in relation to what you do, what are you protecting, why and how from an IP point of view, because that's a key issue that investors are going to want to dig into, because IP is very often these days, and particularly for tech businesses, deep tech, life sciences and so on, IP is a fundamental part of the business assets, obviously, and protecting what the business creates and protecting the future revenue streams is absolutely key for investors to see. They want to see a coherent story on that front, backed up with detail of your registered IP rights, your unregistered IP rights, and to know what you're doing to protect all of that. Their lawyers are going to dig into, is the IP ownership documented sufficiently within your business, for example? Do you have effective and correctly executed employee contracts of employment, contractor agreements, other agreements with third parties that might have contributed to what you're doing, collaborators? Do you have all those contracts in place, and do they say what you think they do? That's really important to get to grips with before you get into the due diligence process, so that you're not tripped up. And then use of third-party intellectual property within your business should be clearly documented. There should be a policy. Again, you should be able to talk to this convincingly and be able to then explain and point to the detail of the inbound licenses that you have, or the use of open source software if that's relevant, and so on and so forth. And then commercial contracts. Make sure that you've identified, you've got copies of complete PDF, including signed signature pages for all of your key or your material, supplier, customer and collaboration agreements. What does material mean? You're in a data room, you're normally expected to provide material contracts, which really means anything of significance, whether from a revenue point of view, a risk point of view, a criticality to the business point of view. You need to identify those contracts and make sure that you've understood the scope of the ongoing obligations, the liability, change of control and termination provisions. In other words, what is the scope of the commitment on both sides? So your investors are going to be, potential investors are going to be interested in what is the scope of the commitment under a particular customer contract, for example. Is it a framework? Is there a future purchasing commitment? And if so, what does that look like specifically? This is something that the lawyers for the investors are going to go into in quite some detail. So in the run-up to the investment process, don't just sign things hoping they're okay. Make sure you've got a legal review. Make sure that you're checking out the key terms, and make sure that you're comfortable with what you're signing, because all of those material contracts are going to go into the data room. The investors and their lawyers are going to pore over them. And employment contracts as well. Make sure those are in place, especially for key staff, but ideally everybody. Make sure they're adequate. Make sure they're validly executed. Dealing with IP properly, for example, is really important for businesses that are IP rich. And then make sure that the option schemes that you have, the staff benefits regimes and policies and procedures are all properly written and correctly implemented in your organisation. And finally, if there are any disputes, any litigation matters, do what you can to tidy them up and draw a line under those before you get into the investment round processes specifically. It's just the distraction if there's ongoing disputes, any ongoing litigation. And the key message here really is get data room ready. Get ready to have all these materials and documentation ready to put into the data room. Make sure that you know the key messages, the key things that you can talk to in your investor presentations, and everything will then match up and sync nicely for investors that are on the receiving end of all this information. And operate your business as if due diligence could start tomorrow. Don't just sign something quickly without thinking about it, and so on and so forth. Make sure that you're keeping in mind that what you're doing is going to be scrutinised. So how can I help? Well, I work as a consultant. I'm a commercial lawyer by background, specialising in tech and IP. I can work on an ad hoc basis with you to get NDAs in place, to negotiate and draft customer contracts, procurement contracts, collaboration agreements, intellectual property contracts, technology licensing agreements. I can do all of that, right up to working as a fractional general counsel with you to advise and assist you on strategic legal matters and to handle legal matters for your business on a retainer package of a day or two a week. For example, there's a number of different ways I work with businesses. For details, have a look at my website and drop me an email to chris@techgc.co.uk if you'd like to have a chat about how I could help you. Thanks very much. Bye.